My lords, in every democracy, since time immemorial, some degree of interception powers have been granted to intelligence agencies and law enforcement agencies in certain exceptional circumstances. The Union does not contest the fact that citizens do have a constitutionally protected right to privacy. However, this right has to be understood in the context of the state's duty to protect its citizens in the face of modern dangers. And it is the Union's position that the current scheme created by the Telegraph Act, the Telecommunications Act, and the Information and Technology Act perfectly straddles this balance between ensuring the safety of citizens while also ensuring that the right to privacy is protected by several self-contained safeguards both in the statute as well as in the allied rules. I will make my argument, my lords, in two broad parts. First, preliminarily, I will submit that this is an already settled question of law in the case of PUCL versus Union of India, and there are no compelling reasons for this court to reconsider that decision. Secondly, my lords, on merits, I will submit that the scheme created by these acts constitutes a valid restriction on the right to privacy and meets the proportionality test laid down by this court in the case of Puttaswamy. But before I get into my substantive arguments, my lord, a small clarification on the text of Section 5 of the Telegraph Act that the Learned Counsel referred to. My lords, it does not grant discretion without a cause to the executive. If I read the section, it says, on the occurrence of any public emergency or in the interest of public safety, the central government or the state government may, if satisfied that it is necessary or expedient to do so. So the requirement of necessity and expediency continues to exist in the statute.
What was that fact?
My lords, a two-pronged response to that. Firstly, my lords, what has been challenged by Mr. Bhuvan Latta is the constitutionality of the provisions themselves. In case Mr. Bhuvan Latta believes that the interception has happened illegally, he has remedies under Section 25 of the Telegraph Act, which deals with illegal interception.
Notwithstanding that, what was a compelling interest that required you to intercept in this case?
Absolutely, my lord. My lord, the statute requires two things. Firstly, it requires us to have a prerequisite of public emergency or public safety, followed by the interception having to be on the grounds laid down in Section 5.2, which mirror the grounds under Article 19.2. The way the term public emergency has been interpreted by the courts is found in the case of PUCL versus Union of India, where the court has interpreted public emergency to not just mean any form of emergency, such as an economic emergency, but a very particularly grey form of emergency. In the present case, the country was going through a raving pandemic. There were huge public health concerns in mind, and it was in that context that the Union government found it necessary and expedient to exercise its powers. However, my lord, I must point out that under both Rule 419A as well as the statute, the actions of the executive and the interception orders cannot be challenged. And in fact, for that very same reason, they have not been challenged by the petitioner as well. The only challenge made by the petitioner is to the constitutionality of the provisions themselves and not the application of this statute in a particular factual circumstance. So if I could satisfy my lords on the constitutionality of the provisions themselves.
Tell us.
Yes, my lords. My lords, because in the, my lords, just one last point before I move to that, because in the specific context of the facts, there are already self-contained safeguards. There is a review committee which will look at the interception order and check whether it complies with the provisions of Section 5.2 or not.
By which time damage will be done.
My lords, the review committee has the power to not only set aside the order, but also order for destruction of all the data that has been intercepted pursuant to that order.
It's already been circulated and everybody has
my
seen
lords,
it. What remedy does?
My lords, the fact that a media outlet got access to that information is something that is subject to investigation, and again, the petitioners may invoke Section 25 of the Telegraph Act to challenge how the media outlet got access to that.
They could have got access only from you.
My lords, that is a subject of investigation and does not bear on the constitutionality of the provisions themselves. So if I could satisfy my lords on the constitutionality of the provisions. My first argument is that this is re-agitating a settled question of law. I must clarify, my lords, what happened in the case of PUCL versus Union of India. In the case of PUCL, a two-judge bench of this court upheld the constitutionality of Section 5.2 of the Telegraph Act. At that time, back in 1997, the government had not enacted any allied rules which is why the court found that there might be some procedural directions that they should give in the interim. After PUCL was passed, the executive has enacted Rule 419A of the Telegraph Act, which contains not only the safeguards in PUCL but also a host of other safeguards. And therefore, this question of the constitutionality of the substantive provisions is already settled. In fact, my lords, in the case of Puttaswamy versus Union of India, it was PUCL versus Union of India that was quoted with approval and formed an integral part of us locating our right to privacy. And therefore, there are no compelling reasons for us to turn back and again reconsider the question of law settled in PUCL versus Union of India. My lords, moving on to my submission on merits, it is the Union's submission that the scheme created by these acts meets the proportionality test. I will not take my lords through how the proportionality test came into being and the various formulations. I will rely on the precise formulation given by Justice Sikri in the case of Puttaswamy 2. If my lords refer to paragraph 319 of the judgment, it's at PDF page 1339, a four-pronged test was laid down. Firstly, the measure restricting the right must have a legitimate goal, that is, there must be a legitimate state interest. Secondly, it must be a suitable means of furthering this goal, that is, there should be a rational connection. Third, there must not be any less restrictive but equally effective alternative. And finally, the measure must not have a disproportionate impact on the right holder. That is the balancing stage of the test. My lords, it is a well-accepted position of law.
Can you make your submission without using the expression, my lord?
Absolutely. It is a well-settled position of law that public safety, national security, crime control constitute legitimate goals. This was recognized in the case of Puttaswamy 1 as well. Justice Chandrachud, as a learned Chief Justice then has recognized as national security is a valid state interest at paragraphs 309 to 311, which has also been echoed by the other judgments in the case as well. So the first test is undoubtedly satisfied, that is, that there is a legitimate state goal. The second is whether there is a rational connection between this state interest and the actions of surveillance. Undoubtedly, my lords, it is our submission that there is. In certain circumstances, intelligence agencies and law enforcement agencies need to intercept messages for prevention.
What's the connection?
My lords, in certain cases, interception assists the enforcement agencies in conducting investigation, prevention, and also in ensuring risk assessment.
What was the investigation you were conducting?
My lords, in the facts of this present case, my lords, there are certain allegations of corruption that are being investigated, but again, my lords, these are matters of investigation and not subject to judicial review, at least at this stage, where the constitutionality of the provisions are being challenged. My lords, now coming to the thorny parts of this test, which is the necessity stage and the balancing stage. The necessity stage broadly means that there must not be any less restrictive, but not equally effective alternative. The way the necessity stage has been interpreted by the courts is important. Justice Sikri in Puttaswamy 2 was clear that to satisfy the necessity test, one does not need to prove that what the government is using is the least intrusive measure or that there is any measure.
We have a strong suspicion that the government has taken it up for political reasons.
My lords, in the present, again, if you are referring to the present factual...
See, that itself shows that the provisions have been misused.
My lords, it is a submission.
How can the government...
And which part of 5.2 are you invoking to intercept a conversation like this? How does it pass that test?
My lords, it is our submission that the interception in the present factual situation was done under Section 5.2 of the Telegraph Act as well as Section 69 of the IT Act. The IT Act mirrors the provisions of Section 5.2 with an added ground, that is investigation of any offence when the government believes it's necessary and expedient to do so. So it is under that ground that they...
More of a fishing and roving inquiry, isn't it? Where is the basis for such an interception?
My lords, again, in the factual circumstances of the interception that has come out in the media, it is subject to the review committee checking whether it was in compliance with Section 5.2 and Section 69. And the review committee is mandated to ensure that it is in compliance with these provisions. If the review committee constituted under Rule 419A believes that it does not comply with these provisions, the order will be set aside.
Are there any loose ends in the statutory provisions as government you would suggest that bring it in the subordinate legislation?
My lords, it is our submission that as the subordinate legislation stands currently, it is the most effective way of conducting surveillance while also ensuring that the right to privacy remains protected. My lords, because three things are required when it comes to surveillance. That is exactitude, speed, and utmost secrecy. And it is our submission that any other alternative, be it things like judicial scrutiny that was suggested by the Learned Council, would not be able to meet these three requirements.
But have they been met now?
Yes, my lords. It is our submission that the present procedural safeguards, which is that A, the order has to be in writing, B, the order has to be on very narrowly specified grounds, 3, this order has to be mandatorily sent to a review committee, 4, this order must clearly state reasons as to why this information could not be brought in any other manner, could not have been received by the government in any other manner. And 5th, the review committee has the power to set this aside. And my lords, if I could take you through a few more.
Does the appellant or anyone else get an opportunity to read this order?
No, my lords.
Do you ever share this order post the interception with them?
No, my lords. And that, my lords, is in the interest of secrecy, that the order is not shared with the subject of surveillance. My lords, because the point of surveillance will be defeated if the subject of surveillance is aware that
the surveillance is done post facto.
My lords, but the fact that the surveillance was done, the information collected during, the fact that the surveillance was done is an important data point for our law enforcement agencies, which cannot be revealed to the subject of surveillance themselves. In fact, my
You will
lords,
disclose it to the court?
my lords,
Or you will seek immunity?
my lords, under the current statutory schemes and the rules, the data is only, the interception order is only revealed to the review committee, and that is also, my lords, in the interest of secrecy and in the interest of the right to privacy as well. Which is why, my lords, the interception is for a time-bound period, first for 80 days, and it may be extended up to 180 days. And after the interception is complete, all the information as well as the order is immediately destructed, which ensures that both the privacy of the individual is maintained, while also ensuring that
the privacy was clearly not maintained in this case. The order was shared with the media, and the media did expose. So where was the privacy?
My lords, I fairly concede from the Union of India that the media getting access to the telephone call, provided that was actually a call that was intercepted, was a lapse in the procedure as it stands. But I believe that one case of potential misuse cannot be a ground to challenge the constitutionality of the procedure itself. And therefore, my lords, I would like to satisfy you on the constitutionality of the provisions itself. So, my lords, having satisfied you on the third prong, which is that there is no other equally effective alternative that is less intrusive, we finally come to the last prong, which is that of balancing. That is whether there is any disproportionate impact on the right. If my lords look at Rule 419A, you will find it at page 2. If I could just get a minute, my lords. On page 2 of our compilation, there are 19 procedural safeguards that are in place to ensure that the right to privacy is not unnecessarily violated. Moreover, my lords, just to clarify, when my learned counsel states that things like public emergency and public safety are broad terms, and therefore they are overbroad phrases that should be struck down under Article 19, it's important for us to recognize how these phrases have been interpreted by the courts. If I could quickly read a paragraph from the case of PUCL versus Union of India, the court relies on the decision in Hukumchand Shamlal versus Union of India to understand what a public emergency and what public safety really is. The court says, as a preliminary step to the exercise of further jurisdiction, under this section, the government or the authority concerned must record its satisfaction as to the existence of some emergency. Further, the existence of the emergency, which is a prerequisite for the exercise of power under this section, must be a public emergency and not any other kind of emergency. The expression public emergency has not been defined in the statute, but contours broadly delineating its scope are discernible from the section, which has to be read as a whole. In subsection 1, the phrase occurrence of any public emergency is connected with and is immediately followed by
What is the
phrase,
public emergency here?
My lords, it is our submission that...
Pandemic.
Yes,
but
sir.
that will have no bearing on
a conversation.
On intercepting.
My lords, the fact that there was a public health crisis caused by the pandemic does mean that there was a public emergency. However, this is only
so
step 1.
whenever there is a public emergency like COVID, you will start intercepting all
my
calls.
lords. That is only step
Then
1
why
of what
did
the
you do?
statute provides. Step 2 is that even if there is a public emergency, that does not mean we can surveil anyone. even then, the order has to satisfy that it was necessary and expedient to do so in the interest of sovereignty and integrity, public order, and so on.
So how do you satisfy step 2?
All of which are grounds that mirror Article 19.2. My lords, again, these are, the order is not, we don't have the benefit of having the order of the Home Secretary with us today. However, in case it is found that it does not comply with Section 5.2 and it has not met the procedural safeguards of 419, the review committee will set it aside, my lords. I can assure you that the review committee, constituted of high-ranking officials of the government, will ensure that the contours of Section 5.2 are satisfied.
We also have some information that the review committee is overburdened with so many interception orders and is therefore it is incapable of setting aside any of them without just mechanically doing that.
My lords, at the level of the Union government, efforts will be made to ensure that the review committee can work more efficiently. But as things stand, given the importance of
that is your big point, no? That the review committee will set it aside if it is found to be. But the review committee itself is functioning mechanically. So is that an adequate safeguard?
My lords, it is our submission that the review committee as it stands is not functioning mechanically. It consists of very high-ranking officials of the government, such as the cabinet secretary, the secretary to the Government of India, legal affairs, and so on. And these are not authorities who will merely rubber stamp an order. They are mandated under Rule 419A to ensure that it is in compliance with 5.2, and more importantly, this information could not be brought in any other manner. Therefore, the proportionality analysis is also conducted within the government as well.
Thank you.
Thank you, my lords.